UK immigration lawyer, level 3 immigration advisor, doing appeals, advocacy, etc. Most of you know me. I'm again live. I have some time this weekend, so I'm doing some repeated lives and answering a lot of questions that are on the channel. Anyone coming live can ask their questions. I will be live for about an hour now. To begin with, I will take the questions on the channel. I'll take the questions on the channel. Anyone coming live can ask their questions. I have a question on the channel from Ola Khan Boboye. I got my visa on 21st of June 2023, but my dependent got her in December 2024. Okay, the visa is due July 28, it's expiring. If I apply for ILR if I am due for ILR for 2028, can my wife apply at the same time with me? No, your wife won't be able to apply. You can apply first as the main applicant. You will complete your 5 years in 2028. Your wife may have to apply for a further extension, and the usual extension is always applied for 3 years. You cannot get a 1-year extension. She will end up paying 3 years of immigration health surcharge for the PBS dependent partner extension. So just to help you with that, if no, do I need another cost from my employer for the dependent to apply? No, you don't need another cost for the dependent to extend her permission. The dependent is based on you. If you apply for ILR at the same time as her, permission will also end on the same date as yours, your skilled worker. Her dependent will end on the same date. Both of you can apply for extension. You will apply for ILR, she will apply for extension along with you. Both applications can go together. This is how we usually do. We, in our covering letter, legal representations letter, we tell the case working team to keep the dependent's application on hold. We ask them to process the ILR first, and once that is decided, then process the dependent's extension. The dependent's extension can only be applied for 3 years. That is the situation now. Many times we've asked Home Office, can we do an extension for 1 year, 2 year? We've tried to raise it to them many times, but it is a standard extension. Till now, they have not changed. You have to file for 3-year extension, pay 3 years of immigration health surcharge and 3-year visa fees. Okay, but she would not need a cost because she's just a dependent. Okay, I've answered both parts of that question. Second one I have from Ronaldo. It's a comment, sir, past 1 month your videos are very less audible. Yeah, if anyone is having issues listening to this video, please let me know. One of the subscriber is telling me, Ronald, that the video's voice is very low. I've tested it on my computer also. It seems okay for me. I've changed some settings also. Even if in our full volume we can hardly hear you. Okay, I'm not sure if anyone is facing the volume issue, please let me know. Okay, I'll take Emma's live question. Okay, I am on a chef visa, course issued before April 24. Transitional provisions apply. Okay, I would like to change sponsor and new job title is kitchen manager. Am I allowed? Can I change jobs? First question. Yes, you can change jobs. There is nothing stopping you from doing that. The transitional provisions will apply. The base salary of 31,300 will apply. When you joined for the first time, the base might have been 25,600. It subsequently increased to 29,000. Currently, the base salary for the transitional provisions that apply to you for changing job or extending your visa also is 31,300, or the going rate for your job code, provided kitchen manager is in one of the sponsorable job codes. You need to make sure that it's in the skilled occupations. So that is important, and your base salary will be 31,300 or the going rate for that particular job code, whichever is higher. Okay. Okay, I've answered that. The next question I have is, can I apply SOC 2-4? Okay, Emma, as this job is RQF level 3 and someone said that the new rules will apply. So your previous was also 3 and old was also 3. Now, because you joined the skilled worker area and the transitional provisions apply to you, you can still extend level 3 jobs or even be sponsored for level 3 jobs. So the change is that someone is telling you, it will only apply for someone who is joining the skilled worker area for the first time. You come under the old rules, so you can continue extending, changing employers in the level 3 jobs. That is what Home Office has clarified to us as well. Preeti, Mahi, how much time does it take to get British citizenship? From which point are you asking me? Once you get indefinite leave to remain, if you are married to a British citizen, you can apply immediately. If you are not married or in a civil partnership with a British citizen, you need to wait 12 months, 1 year after getting indefinite leave to remain. That is the current rules. Okay, Devjyoti Saha, I'm getting calls from my company. I have a question on whether I am a new entrant or not. My background is I have done my master's 2 years and then graduate visa 2 years. Am I still a new entrant? Yes. Since you are switching from your graduate route to the skilled worker route, you are a new entrant. I'll help you further as well. The base minimum salary for you is 33,400 as of today. Earlier it was 30,960. It has increased to 33,400. So that is your base salary for the new entrant, or the 70%, yes, 70% of the going rate. And the standard going rate will apply to you because you are joining the route for the first time. The new rules apply. So yes, you are a new entrant. The employer has to check mark on the course which says new entrant. They have to put a right mark on that. And new entrant can only be sponsored. You can only get further 2 years from the point of your graduate route expiry. So remember, you can only initially you will have to apply only for a 2 year permission, skilled worker permission, if you are taking the new entrant benefit. And after that, you will have to extend further for 3 years under the experienced worker salary, standard salaries. And whenever you extend, the standard salary currently is 41,700. That will apply at that time. Preeti Mai, thank you very much. If it did help you, please do. I do recommend, if you can give a comment, give a review on Google for us. There are many people who are not aware of the channel, the Google business, which is the location based. It is somehow not connected to this YouTube channel. It is not showing up. We are trying to post videos and all. There are many people like you who are in need of advice and immediate answers like this to decide about their lives. So if any of my answers have helped anybody, Preeti, please do review and help others find this, and also help us find viewers. I'll put the link. This is the Google review link. You can just click on it and it will take 1 minute of your time, but it will help others as well to find this live and the other resources on the YouTube channel. A lot of free resources are there, list of documents, checklist, a lot of things are there. So Emma, one question of my friend's behalf, okay? Her course issue 21 July and job is RQF level 3 and she has not submitted application yet. So her dependent will be allowed or not, as application was not submitted. So dependent is allowed 21st of July, August, September, October. So her course will expire by 20th of October. She should submit an application before that date. That's first answer for her to help her. Secondly, yes, dependent can join provided she is in not of any of those care worker job codes 6135 or 6136. Other than that, then those, because it was on 21st of July it was assigned, dependents can join except those two job codes. If she, I'm assuming she's not on those two job codes. So that's it. Yes, dependent can join and she can file wherever the dependent is has not submitted an application. So a dependent will be allowed or not, as the application was not submitted. Yeah, dependent can apply together, or once she is approved, after that also dependents can apply because she will be under those rules. Muzammil, I have received reply from paid inquiry today that the decision is made for my student visa application, but they can't share it online by telephone. What does that mean? Yes, that inquiry team is like a customer service team. They cannot give you that. The case working team, so the way it works is whenever you make that paid inquiry, whatever by email or calling them, they raise kind of ping the case working team, and The case working replies to them that answer, that's what they've given. We've made a decision, and yeah, shortly that decision will be sent to VFS, the Visa Application Center where you applied, and they will contact you. So the decision is only given to you directly when you receive your passport, either in the courier or if you go and collect it. Other than that, you will never get a decision from anyone, neither from VFS nor from Home Office. It is only in that envelope that you receive, either in the courier or if you collect it physically. That customer service will not get a decision. They will only get an answer, yes, decision is made, or it is not made, or we are working, whatever. That's the only thing. An update from the case working team. They wouldn't even tell lawyers. If I ask the case working team, they wouldn't give me a decision. They will always send it through that channel only. Emma Smith, it's code 1451. As she read guidelines, and it says that if application was submitted before 22nd July, then dependent are allowed. In her case, not cause assigned before 22nd July. As she read in guidelines, and it says application was submitted before 22nd July, then dependent are allowed. I don't know whichever guidelines she is reading, but this is from experience. I can tell you, we have also filed applications, other lawyers have also filed, and we know from Home Office clarification also, course assignment date is what matters. So the date of application does not matter. That's what Home Office also clarified to us. I can only tell you what has been told to us by Home Office. Emma, thank you very much. Yes, if you did get value in your 3 or 4 questions that I answered, please do consider giving a review. Give a 5-star review. It will take 1 minute of your time, but it will help someone else find this live, find the YouTube channel and the resources. I would request you to please give a review in 1 minute. Just write a 1 line, whatever your experience is, and I'll be grateful. I'll put the review link anyways again. This is the review link. If please do prefer giving the reviews, anyone who's getting value from this live. Okay. No more questions. I'll take the questions on the channel till the time I get any live questions. Apply SOC. Okay, this is another question about the degree level. So the job should be degree level, not that the applicant should have a degree. Yeah, I'm again stating that. So Debjyoti, again another live question, another query from the previous one. New enter eligibility also says, thank you very much Muzammal Saeed. Please do consider giving a review. Yes, you heard me before. The link is there on the Simply Sachin comment over there. Please click on it. It will take 1 minute of your time, and just give 5 stars, write 1 line, and that Google business is somehow we are trying to connect to this channel as well. Okay, another query from Debjyoti from the previous one. New entrant eligibility also says spending 4 years in the UK. So I'm confused. My uni started on 20th of September 2021. Course ended 20 September PSW. Okay, so yeah, don't worry about all that. Yeah. So the way I would calculate if I'm filing your graduate route is from you got your graduate on 1/12, 1st December 23. Let me do it for you here. 1st December 23. So you got your graduate route on that. So I add 4 years to that. 27 December. So I'll give you an answer that you can tell your employer also, whoever is assigning you the course. Your work end date on your course for the new entrant should be latest 1st of December 2027. I did calculate it. So the way it works is 4 years from the start date of your graduate route. Your graduate route started on 1st of December 2023. I have added 4 years to that, which is 1st of December 2027. So your work end date on your new entrant certificate of sponsorship, there are 2 dates. Work start date can be any. I don't care. It can be any. So it has to be usually within 3 months of the date of application of when it is assigned. But work end date is what matters. So 1st December 2027 should be your work end date, just to help you out. So till that time, you can be sponsored as a new entrant. What about 14 days extra after 4 years? After 4 years, yes, they will top it up on top of that but you cannot apply that. Yeah, so I understand that they will always give that 14 days extra, but the courses should be assigned as per the rules. Okay. Yeah, you will get the 14 days extra on top of the permission grant anyways, that is normal. But yeah, the cost should be assigned to be ending 4 years from the start date of your graduate route. That's how you count it. Okay, I'll take another question on the channel. So 14 days includes 4 years. I don't think so. They top it up 4 years plus 14 days. That's how they will give it. To the best of my understanding. That's how it says on the grant. Let me check anyways. Appendix, skilled worker. Okay, grant. Just find it in the rules. Relevant grant. Where is it? Hide all sections. Decision on the application. Periods of grant. The applicant will be granted clearance permission to stay 14 days after the end date of the certificate of sponsorship. So it will be given 14 days plus the end date on the certificate of sponsorship. So that's how it is added. And the end date on the date of sponsorship may be up to maximum of 5 years. So that doesn't apply in this new entrant case. And this after the start date of the certificate of sponsorship. Okay, the applicant is going to be sponsored on this. Then they give you the permission 4 months of the end date. Yeah, 14 days is on top of the course end date. That's how it works. I'm looking at the immigration rules and this is what I'm reading over here. SW 18.1, this is what it says. I'll put it on the chat also over here. This is the immigration rules, you will see it on screen. SW, skilled worker 18.1, appendix skilled worker. If you Google search it, you will find it. Applicant will be granted entry clearance or permission to stay until 14 days after the end date of their certificate of sponsorship. Okay. Next question. Anyone coming live can ask me any questions. I have one on the channel. Can I apply SOCO 2461 social care without degree? Yes, you can apply any skilled worker visa without a degree. The job level is degree level, not that the person should have a degree. I have applied for voluntary return to India. I've applied for my passport as well through this scheme. It will take to get travel documents. Usually voluntary return scheme will take between 1 and 4 weeks time approximately. You should email them and call them and follow up with them as well, because this you have to send them the e-ticket if you are paying for the ticket. Then they send the passport to the airport, and once you are at the airport, you are given the passport and you go on your flight. That's how voluntary return works. Any guidelines link like above in my 2 questions? On the second question, no, there is no link. It's only from experience I can tell you about the date of application and date of course. In the first one, what was that? RQF level 3. Yeah, it's I won't be able to find it very straightforward. It's a lot of knowledge that I have gathered together, immigration rules, guidance, whatever we've asked them, practical experience. There is nothing that I can give you in writing. This is the only thing that I can show you. Yeah, I may be able to show some things, yeah, but yeah, that takes a lot of research. There will be something in the guidance and all, I can find it. But yeah, for that, book a paid consultation with me. There is a 10-minute option and there is a 30-minute option also. The 10-minute is charged at £60 for 10 minutes. You can book that. I can try to give whatever references I can find. But yeah, it does take researching and digging around. Consultation links will be in the description of this video and other videos. Okay. So, Devjyoti, TSOL, temporary shortage, temporary whatever TSL you're talking of. Temporary shortage list jobs don't have new entrant discount. Yes, they should not have new entrant discount. Why do I say so? Let me check. I think they should. Anyways, I will take Emma. When is this live option and how long? When is this live option and how long? I don't understand the question. Yeah, I will be live for about under an hour, maybe 45 minutes now. And if you are asking for a consultation, the links will be in the description. I'm also putting the consultation link over here. If anyone wants to book the consultations, if so, then the recent graduate has to meet the general threshold, and general skilled worker has 41,700, and TESOL has job specific thresholds. Job specific, okay. So what you mean? Temporary shortage list. Let me find it, 1 minute. Under the current English skill, you cannot combine salary discount for the job on the English salary list with the discount. Yeah, you cannot get both discounts. That is what the rules say, because the immigration salaries list salaries are already discounted. So you cannot combine the salary discount for a job on the immigration salary list and with the discount for the being a new entrant. You can't get double discounts. An applicant must be qualified one of the following discounts. So if a job is on ISL, which replace the shortage occupation list, it benefits from lower minimum salary. The required salary is, yeah, so for TSL anyways, the required salary is 33,400 if I'm not wrong. TSL, yes, it should be 33,400, I think so. So that is already discounted. You can't get both discounts. If so, then the recent graduate has to meet the general threshold. No, for the TSL, there is already that discount there. So that they have to meet that discount, not 41,700. So you will get either 33,400 as a new entrant or 33,400 as a TSL. Joyman, whether I get costs, then my wife and children can change to dependent visa. Whether I get costs, I'm not sure what you mean. If you get a cost now, and if you are at a level 6 job, so if your RQF level of your job code is 6, only then you can sponsor dependents. If you're joining the skilled worker area for the first time. Okay, I'll take the questions on the channel. Tejaswini, student 2023, and without any reason the university has cancelled my student sponsorship. Interesting. I have no option to fight back, but no response to a lawyer. I have been on FLR in these situations. I haven't passed final registration. FLR helped me to get through, but I have submitted passport and biometrics. I have passed on chair, but the university again haven't informed my office that I've cleared my matters. Bail. Then I was on immigration. Then new solicitor came up with applying for bail lift and put me on set B. Okay, so just be aware of all these frauds that happen. I don't know whoever is doing this. So this individual Tejaswini, it looks like, yeah, whoever is filing these applications, FLRs, and then she being put, her immigration situation is worsened like to almost zero or almost minus. Someone made her file an FLR. Obviously, that FLR was refused. Whatever happened with the university, they have curtailed her permission. I think they wrote to they cancelled the student sponsorship. That's what she says. She's trying to fight back with the university, and whoever she has approached, that individual lawyer rep, whoever that is, has filed FLR. That FLR refused. She was on immigration bail. At that point, ideally, you should leave the UK. You can sort out that, or whatever that fight is, that is a private contract between you and the university separately, that can be challenged in other courts. But just staying on that immigration bail, and she went to another lawyer, and that is a fraud. I have that set p fraud. I've already exposed that. Set p is not even an application that students or anyone should make. Set p is a refugee ILR form, settlement ILR. Those people, whoever they claim to be lawyers, reps, whoever that is, they are just taking monies from you and abusing the system. That set p is complete nonsense in filing. Set p is, we use ZP when it is for a refugee who's lived in the UK for 5 years. They file settlement. That's called as settlement. Settlement for refugees. That's a form. They are filing that because it's a free application for refugees. They just use that and file it and take money from you guys. You should not fall for that. If that has happened, I would advise leave the UK. Anyways, that application would be refused subsequently. You will just ruin your immigration situation, whoever has done that. But don't fall for all those FLR frauds, ZP frauds, whatever that is. Put you on ZP, which means they filed the ZP. So some people may have been known regulations very well, but me as student as well. So yes, so now you are aware that that's a fraudulent application. It's a frivolous application. I understand you may not be aware at the time. So now maybe you should withdraw that application or leave the UK. Application will be anyways withdrawn, and sort out that university issue back home. You are just building up a long overstay on your record. That's the only suggestion. Sunny Patel, hello boss, I'm issued my extension course for 2 years for sales executive. In course, I am not ticking this tick to confirm ISL on TSL. Any impact on my visa? I am tick is job is eligible list only. What do you mean? I'm issued extension course for 2 years for sales executive. Yeah, sales executive may not be on the ISL or TSL. I'm pretty sure that government will not put a sales executive job on any of the shortage lists. So yes, you should not take those anyways because they are not on those lists. But what is your question? If you are eligible or not, I don't know when you joined the skilled worker area for the first time. That sales executive may be a medium level job, maybe a level 3 or 4, under 6 definitely. That's what I am assuming. I'm issued my extension course for 2 years. Extension course. When did you join the skilled worker area? When did you get your first skilled worker visa? Accordingly, I can answer. Deepjyoti, thank you. Does the rule 10-year legal stay for ILR still valid? Yes, the 10-year long residence applications for ILR are still valid. That should be a combination of any permissions except visitor visas or temporary permissions. Other than those, all visas can be combined: student visa, graduate route, skilled worker visa, care worker visa, all of them. 10-year long residence rule is still there. You have been here for 4 years, 5 years on skilled worker will be 9. Can I get one more year of skilled worker? But you don't need that one more year of skilled worker. If you complete 5 years on skilled worker visa, you will qualify for indefinite leave to remain, being 5 years on the skilled worker visa only. You don't have to go for the 10-year. Varela Almeida, I have an ILR more than 10 years ago, but I spent more than 5 years outside the UK. I have the e-visa now. I have been to the country 2 years straight. Can I apply for citizenship now? For citizenship, they will look at last 5 years of your residence in the UK. In the last 5 years, you should not have been out of the UK for more than 450 days. Up to 480 days, they will ignore, but that's the maximum. In the last 12 months, you should not have been out of the UK for 90 days, or maximum up to 100 days they will ignore. If you meet these residence requirements, only then you should file for naturalization as a British citizen. I don't think you can file because you have not lived in the UK in the last 5 years. That's what you said. More than 5 years outside the UK. You need to build that residence period. Look at last 5 years, see your absences. You should be within the allowed absences. Sunny Patel, I'm issued costs before 4th April. Yes, so you come under the transitional rules, an extension in this September. Yes, you can extend on that level 3 job, the sales executive. You don't have to take on any of those ISL or TSLs. You should be eligible for extension because you were eligible for a level 3 job, level 3 or higher job at that time. You continue to have that right. You can extend at a level 3 or higher job. So Sunny Patel, you are sorted. Don't need to take on any of those job codes, TSL, ISL, whatever that is. Okay, next question I have on the channel. My employer has sponsored me since September 23. Has changed. Okay, let me take the live ones first. As you are live, I will prioritize you. Tahir, I am from outside of UK under 26 and my job is on TSL. 26 and TSL as business support officer. So how much minimum salary qualify? You can only get one of the discounts. Remember that if you want the temporary shortage list, you only get that discount. You cannot get the new entrant discount. If you want the under 26 new entrant discount, then you cannot get the TSL discount. 33,400 will be the base salary minimum that will have to be paid, or the going rate, whichever is higher. 33,400. List. Temporary shortage list salary. Let me check. Okay, your job is on the medium. Yes, 33,400 is the base. I am right. Okay. Next question I have on the channel is, hi sir, my employer has sponsored me since September 23. He has charged £15,000 for 3 years. Okay. He hasn't given any breakdown of the costs ever since. Okay. I was afraid of all the new rules at that time. I paid the fee blindly. Now I am about to switch to a new employer. Good if he does not. Yeah, this is where the, so maybe you have bought the visa from your employer, you paid in them £15,000. I'm pretty sure that is more than what is the visa fees. So kind of you are also a part of the fraud on the immigration. That's how Home Office will look at you. So now if you want to leave that employer and you want to get that money back, it is kind of an immigration fraud that you have done along with the employer, both of you together. You will not be able to challenge that. If you challenge that, obviously Home Office will also have compliance action against you. So your current permissions may be curtailed and you may be asked to leave. So be careful if you are trying to just get the money. So you were a party to the fraud till the time everything was fine, and now you want to, since you find another employer, you want to get out and get that money back. That it doesn't work like that. Life doesn't work like that. If you report, you will also have the consequences of your permissions being curtailed. Can the course be issued for 5 years and I get ILR if visa granted? If you are taking the under 26 new entrant discount, no, the course cannot be issued for 5 years. It has to be for 4 years max. Yes. If you are taking the TSL option, yes, the course can be issued for 5 years. I know the TSL will end, but you can assign a 5-year course. That is a solution for TSL and ISL shortage lists. You should straight away assign a 5-year course. That's the protection. Yes, the cost can be assigned for 5 years for a temporary shortage list occupation code. Which code fit for the business support officer? Yeah, for the codes and all, I will need detailed job description, and that has to be done in a paid consultation. We charge £60 for a 10-minute consultation, and we have a 30-minute consultation also, another one. Links will be in the description. So all those job code calculations, salary calculations are done in consultations. Okay. Next question I have on the channel. I have a BSc degree, Ganesh. If I get a job as a chef, can I bring my dependent, my family? 1 month before, I don't think. Let me check. Yeah, chef may not be. Chef is maybe on a medium scale. You may not be able to bring your family members if you try to get a job as a chef. It appears it is in a medium scale occupation. Let me check. Yes, it is a medium scale occupation. Let me find it. Medium scale. Salary list. Yes, that will be in the medium scale occupation. So you may not be able to sponsor your dependents if you are joining the skilled worker area for the first time as a chef. Next question I have is Kinjal Patel. I'm registered MSc Finance and Accounting, but I passed module and dissertation. Okay, let me take this live. Ozone 063. What if days outside UK are over 90 in the last year before citizenship application? Should we wait until the number of days reduces in the last 365 days, or are there any other provisions? There are provisions. If in the last 12 months, this question is about naturalization application. If in the last 12 months, absences up to 100 days will be normally disregarded. That is normal. We've done many applications. But if it is over 100, then there is an absence rule that comes into play. Let me briefly explain that. Citizenship absence rule. Okay, so the rules for considering excess absences. If just a minute. Normally permitted absences is 90. Normally disregarded is up to 100, they will disregard. If you meet all other requirements, you pass the life in the UK test, English test, no criminal issues and all of that, then and you have demonstrated links in the UK. For example, you have family, husband, wife, children, or if you don't have that, you have a house, or this is what the rules say: you have demonstrated links with the UK through presence of family and established home, and a substantial part of your estate, your savings, your pension, your investments, your whatever shares, etc., investments, derivatives, whatever you are holding. If you are holding majority of your estate in the UK, you have established home in the UK, it can be a rented home or owned home. If you have family, all these things add up. Usually get this assessed by an immigration lawyer. Then up to 179 days they will allow, up to 179 days in the last 12 months. And above 179 there is further exceptions, but they are very strict on that. Yeah. So yeah, speak to an immigration lawyer. You can book a consultation with me. Link will be in the description. There is a 10-minute consultation for £60 or so. Yeah, if you give me the facts of your case during a consultation, I can answer that. Thank you, Ozone 063. Okay, if you did get value in my answer, if it helped you, please do consider at least giving a review on Google. It will take 1 minute of your time. I think I saved you a lot of time and effort by giving all your answers for your naturalization application. At least if you can do that, I'll put the link over here. It will take 1 minute of your time. Just click on that and give a review. It will be very helpful. I put the link. You can click on it, give a 5-star. It will take 1 minute of your time, but it will help others like you to find this channel as well. There is a disconnect between the Google business profile and this channel. We are trying to connect it so people can find locally as well and come to the lives also on the YouTube channel and get any resources. There are a lot of free resources on the channel, list of documents, etc., etc. Okay, Devjyoti, in HC 997. Okay, says TSOL will be reviewed at the end of 2026, but some lawyers are saying it will be scrapped off. What do you think? It may be scrapped off most probably, but it's the government's decision. So the goal is to scrap it. That is how it has been put. They want to scrap it, but unless things are not working in favor of UK economy, they still want the people. They may reshuffle that list or do whatever to that maybe. But the idea, the goal is to scrap it. Yeah. Temporary shortage list. Hence, if you have the option of getting a TSL job, try to ask your employer to get a 5-year sponsorship. They can sponsor you. Doesn't matter even if the job doesn't stay in the TSL after 2026. It does not matter. If they give you a 5-year visa from now, that's it. You are on the 5-year. At the end of 5 years, you may also qualify for indefinite leave to remain. Thank you very much, Ozone. Okay, Raj, hi. Okay, very practical and knowledgeable. Imran, yes, if it is helping you, please do give those thumbs up and all those emojis on the review. Please, I have put the link. I'll put the link again. Uh, please express your gratitude over there. It will be helpful. It will help others to find this live as well. Uh, I'll put the review link again. It will take 1 minute of your time to give a review. Click on the link, select 5 stars, just write one line, whatever, even you can copy and paste a thank you from here, whatever you want. Okay, let us take other questions. Not able to copy the link and click on it. Yes, this is a common problem. I'll put this link. Can you try to click on this one? This one works. The second one that I put, just latest one. If not, then I've also put it in the description of this video. So if you just close out and go in the description, you'll find you can copy and paste, or the best way is to just do a Google search for this name. Sorry, I'm asking you to do a lot. Just Google search for this Visa Solutions Stratford. Even if you do that, you will get it. We have several locations, but then yeah, there are Google business locations of Stratford also. So just search Visa Solutions Stratford, it will come up first, I'm pretty sure. Yeah. Okay, let me answer some people. Ozonia, please do that. If you cannot click on the link, search for Visa Solutions Stratford and it will come up. Raj Bodu, can I apply? Did I miss anything? No. Can I apply for discretionary leave to remain on the basis of human rights and compassionate grounds from tier 2? You can apply. There is nothing stopping you, but I doubt whether Home Office will just give skilled worker or tier 2 general permission holders discretionary leave unless you have really some exceptional reasons. I don't know what your exceptional reasons are. You can file the application, it doesn't hurt, but I doubt whether there is any provision unless there is really something on your case. They are not going to give discretionary leaves to everyone whose permissions have been cancelled or whatever has happened to your permission. Sorry about that. I know you don't want to hear that, but I'm trying to tell you practical things. I know you'll go to other lawyers, Raj Bodu. They will take considerable sums of money from you, say, yes, human rights, you have rights, this, that, and file applications. They will make money. You won't get anything. It's common practice. You will see that. So be careful of anyone who is telling you get assessed your case properly. Adnan Sagir. Hello, it's good seeing you again. I have already done MS in my home country and plan on doing second MS and then third MS. Okay, and then go for PhD. What problems I may face? You may only face the problem that I don't know exactly how universities assess this. They call something called as progression. So you should be progressing. If you're doing several courses, university may have to justify on their CAS, confirmation of acceptance for studies, that why they are again offering you that particular course, the second course, when you've already done an MS. Why double MS? Why this and that? They have to justify that. Home Office may not just approve applications, and universities may not issue you a CAS. That is another catch usually, because they have that compliance requirement. If Home Office comes to them and they see university has just given the CAS without looking at progression, just written anything, university will lose their sponsor license. Remember that. They have that a bigger obligation. So universities will not take a risk just for one student unless there is something they can concretely prove that there is progression and yes, this person wants MS and again another MS and then again another student visa. So be mindful of that. So Tashi, will salary threshold apply for a care worker when applying for visa sponsorship in N 2020? Will salary threshold apply for a care worker applying for visa sponsorship? Yes, salary thresholds will apply. I think for the care workers, whatever the current are, they may stay more or less the same. I don't think it will change that much for care workers. But yes, whatever the salary thresholds are, they may stay the same or may go up marginally. Raj Bodu, if my employer is doing fraud against me, can I apply discretionary leave? I doubt whether, I don't think you can on that basis. The life lore, my job is business sales executive, SOC 3552 on TSL and over 26. So the minimum salary requirement for me outside the UK. Yeah, it has to be the going rate, or I think 33,400. That's how it will be. TSL, you will have the discount. Yeah, there is a list, so you should be paid that. What is stated on the TSL? What is that? 3552. Let me find it. Business sales executive. 36,700 is what I'm seeing over here. 36,700. That's what I see on the TSL list. That is what you should be paid. Life floor 36,700. Thank you very much for your comment. You are doing a great job. Yes, thank you for that. Watch all your videos. Yes, please do. Life lore, please, if it is helping you, please do I would recommend, I would suggest or request, please do give a Google review. It will help others to find this live and other resources on the channel as you see in other videos. I'll put the link here. It will take 1 minute of your time wherever you are in the world. Please go on Google, give a review, 5-star. It will take 1 minute of your time. Click on the 5 stars, write one line, one paragraph if you want to, uh, and please give the review. It will find help because there is Google business profile. It is somewhere disconnected. Many times I speak to clients and they don't know that there is a YouTube channel. So I'll just put the link over here, and where is it gone? I think the link should work. See, this is a Google review link. If anyone who's getting any value, life floor, you please do give a review. Okay. Devjyoti, okay, live floor, when do you this live show any specific days? No, I'm just doing quite a few this week. I have some time. I have blocked my time. I haven't done for a live for a long time. So I just wanted to do this. Yeah. This is kind of an auspicious week for us. Yeah, there's Navratri going on. So I thought of doing a lot of lives and helping people. That's the reason I am doing these lives 3-4 days now, back to back. Every day I block my time. I'm not taking paid consultations during this time. Uh, just, yeah, that's me. Okay. But yeah, next week also I may do some. Not sure, but this week, yeah, I'm quite religiously blocked my time for all these lives. Okay, in my case, you said 36K plus not 41,700. Yeah, because you are on the immigration salary list, so it is 36,700. 36,700. That is what will apply to you because it is on, which was the list, TSL, ISL, TSL, because it is on TSL. Okay, let me answer Devjyoti's. I think she's put already. So TSL expires 26. Can I switch to general skilled worker with the job specific threshold? After that, can I be eligible for ILR after 2 years in TSL and 3 years? Yes, the answer is yes. I understood your question, Devjyoti, exactly. Yes, you can. So you said 2 years in a TSL skilled worker and the next 3 years in others normal level 6 skilled worker or any other skilled worker, whatever is sponsorable. Okay, Babakar, how are you? Yes, parent visa. I remember your case. Thanks. Thanks for going live consistently. Yes, thank you very much. Yes, live flow rate is on TSL. I have seen it on my other screen over here. So, no changes to parent visa. No update for you, Babakar, yet. Can I watch your recorded show live you done on this one? Yes, it does. This does record, and after that, you can open it. This morning also I did. That one is already saved. So Watch a record show live you done. Yeah, this will be recorded on YouTube, and after 1 hour or after I end it, I think automatically it will be loaded on YouTube. Yeah, it's quite a big file of 1 hour, so I think it takes some time to load on YouTube, but it will be loaded on YouTube. Yeah. So, what are the other questions I have? Yeah. So the question I was looking at on the channel is anyone coming live can ask your questions. I will take them. Kinjal Patel on the channel. Any other social platforms you do show? I'm only doing lives on YouTube now. I have other TikTok and others. I have 7,000 whatever, some 8,000 subscribers over there. Instagram, Insta also. But yeah, I have not been very active on other channels. YouTube is the only one I'm doing it quite regularly. Tashi, along with skilled worker visa sponsorship as a care worker, can a child under 18 years old still be eligible as a dependent child? Is a student here in the UK currently. Skilled worker visa sponsorship as a care worker. If you are a care worker visa holder, you won't be able to sponsor your dependent till the time you are on the care worker visa. After you complete 5 years, as of now, that is the case. Once you get your indefinite leave to remain as a care worker or a skilled worker, then you can. Then what can you do? If the child is under 18, I've got a PBS, but the child never joined me. Then under 18, then you may be able to sponsor your child. It will be under the family route, but once you get ILR, only after that you can sponsor your child. That's how it will work. I hope I've got your question right. Along with skilled worker visa sponsorship as a care worker, can child still be eligible as dependent? No, child may not be eligible as a dependent. Child is student, but the child will have to continue on their own visa, whatever that student visa is, if they have another permission. Life floor, on my friend's behalf, can I ask? Yes, you can ask questions, don't worry. Friend's behalf, family behalf, that's fine. Okay, one, two, no. Okay, next question on the channel I have. Initial cost is received in October 23 for a nursery practitioner. Yes, that one. When the visa is extended in October 26, what is the minimum salary requirement? Yeah, minimum salaries and all, I can only do it during paid consultations. There is a 10-minute consultation for £60. I can do it for you on that because I need to check all the rules properly before advising. What is the minimum salary? Is no longer, yeah, even the SOC is no longer available. That's what you're saying. Definitely, I need to do a lot of research to find what should be the salary. The link for the consultations will be in the description of this video or other videos on the channel or in the channel information. Next question. NG. I have a limited company, started operations from 30th June. It's a legit business, earning 5,600 as a company. Can I still self-sponsor my share? I'm currently in PSW visa, expiring April 2026. So yeah, if it is there's a genuine business, so this is the problem. I'll just go around ranting on that self-sponsorship. Yes, for the next 3 to 5 years, people have been applying for that self-sponsorship since last September 2024 onwards. Home Office has started refusing all these self-sponsorship skilled worker sponsor license applications, or even if license is given, after that they are refusing the skilled worker applications. Almost 80%, more than almost 90% or more applications are being refused for self-sponsorship. The main reason they always say is self-sponsorship firstly is not in the spirit of skilled worker sponsorship. It is for an employer-employee relationship, not to self-sponsor yourself. Lawyers agree, disagree. We have different arguments on that. But Home Office has been refusing these applications for more than a year now, almost a year, since last September, I would say. And they are scrutinizing every self-sponsorship very carefully. Even we have done self-sponsorship where it was a genuine business. The person was on graduate route, generated revenue, business, etc. And after that, it was filed successfully. We have got this in the past. But since last September, Home Office has been giving a hard time to everyone, lawyers or even individually if you file. The main case is, yes, in your case, if you have already generated revenue and all, it is an arguable thing. All that can be put to Home Office, it can be explained. The main thing that Home Office always challenges or has a problem with is they say there is no genuine vacancy in the business for this person. You are just making this up to sponsor this migrant because you are yourself the same person. The business and you are the same. That's how they do it. But yeah, you should get your facts assessed by an immigration lawyer, with any qualified lawyer, or with myself. You can book a consultation and I can advise you on the facts of the case and what are the chances of success, if any. Okay, there's a live question. Jaman Lucas, I am dependent on my wife. She stay back visa. She stay back. If I get care assistant costs, then my wife and children can be changed to dependent. I am dependent on my wife. So you are a dependent. Your wife is the main applicant. She stay back visa. So she is the main applicant. I don't understand what you mean by back. She stay back visa. So she was the main applicant. You are a dependent. I get care assistant costs. So if you get one of those care worker job codes 6135 or 6136, you won't be able to sponsor anyone, your wife or children, because you will be joining the route from dependent. You will become the skilled worker, the care worker for the first time. So you will be under the new rules, and under the new rules you cannot sponsor dependents. Sorry about that. I know you don't want to hear this answer, but that is not possible. Many people are stuck. I know people have tried these applications and they have been refused. I have seen many refusals. I have advised on that. So don't do that, because you will be switching from dependent to main for the first time and new rules will apply to you. Care workers cannot sponsor dependents. Life lower skilled worker visa application submitted 20th July 25. Friend traveled outside UK without biometrics and back now. What to do with that application now? To attend biometrics or withdraw application, and can that cost be used again? Issues. Okay, so ideally home office has clarified this before. After submitting the application, you should not leave the UK. Application will be treated as withdrawn. So by operation of law it happens. Home office may not come to know, but if whenever they come to know, they will reject it or refuse it. So the best thing to do is withdraw the application and file a new one. And can I reuse the costs? If you withdraw the application, then the cost will be unused, and unused costs can be reused. Yes, you should be able to reuse the costs. Preferably do it through lawyers. There are many complicated matters in this. Everything will have to be explained to the new caseworker or the new application. You can take advice from us or go to any lawyer, but preferably do that through an immigration lawyer. Travel due to father's death and dependent visa is still valid. Yeah, because he has still valid permission. He doesn't have to worry. He will not be out of time. So we can come to the UK, withdraw that application, whatever he has filed, and file a new one. He can use the cost again, provided the cost is valid. Okay, remember the cost is only valid for 3 months from the date of it is assigned. If the cost is valid, yes, prepare another one and then file using the same cost reference number, because it is an unused cost, not a used cost. If the application is refused, not decided, withdrawn. And my wife will be allowed if reuse the cost. I'm not sure what is the, if she was allowed on the previous application. Yes, she should be allowed. I don't know the facts, what your wife's situation is, when that cost was assigned and all of that. So I don't know in which, what is the job code and all you are doing. So whether you can sponsor a dependent, whether you are in medium skilled, when was the cost assigned date, I don't know all those facts. I will need all that. So usually, yeah, book a consultation with me or any other lawyer, give them all the facts and only then decide accordingly. Okay, next question I have on the channel is, I have B2 on my IELTS on my first application dated June 2022. Can I use this for renewing or extending my work visa this year? My first application. So if your first application was also a skilled worker application and after that no applications have been refused, so you got a skilled worker application and after that you are renewing or extending, you don't need to meet the English language requirement. On the application form, you just put the right mark saying, I already made the English language requirement for my previous application. That's how you meet it. Yeah, you don't need that IELTS again. 15 July, my wife is on PSW and reusing costs after withdrawing. So is it for the wife? Is it for the graduate route holder? No. So your wife is PSW, you are dependent. So the dependent was becoming the main applicant, if I'm not wrong. So if the dependent is becoming the main applicant and both of them have valid permissions, yes, so the dependent, and it was issued before. So assuming the job code is not any of the care worker job codes, then the wife can be sponsored. So I understand the main PSW holder is becoming dependent and the dependent is becoming main skilled worker. I understood that part. So yes, it can be sponsored. The dependent can be sponsored because the cost was assigned on 15th of July, August, September, October. The application will have to be filed before 14th of October or the cost will expire in 3 months time. So by 14th October, I think the cost will expire. So yeah, that's it. And the dependent can be sponsored as well. I want to know what's your take after speaking. I understand this rule now. There are many ifs and so okay. App for permission outside UK. What is that? I want to know what's your take on this. Okay, I don't know what is that you are referring to. Sorry, I'm trying to find the questions on the channel. Anyone coming live can ask their questions. I will answer them. Sorry, I don't understand what the question is. The question is, I want to know what's your take on this app for application for permission outside UK. Yes, if you are asking, yeah, please clarify the question. Sorry, I don't know. After speaking with many immigration lawyers, I understand this rule now. There are many ifs and buts associated. Not all are aware of those. Yeah, just put your question in detail in the next comment or join a live and ask me. Live lower English test not passed yet, so can be provided after appointment. Usually yes. Yeah. English test can be provided after appointment but before a decision. But how will you provide it after appointment? You cannot be, you may not be able to upload anything after the appointment. So before the appointment, upload your English language test. Okay, that's great news. Will I be allowed to extend my visa by Jan 28 under the new salary threshold that I assume, right? Okay, not many relevant questions on the channel. Anyone coming live can ask their questions, or anyone who's got any value, I'll throw this again. Okay, so please do consider giving a review on Google. It will take just 1 minute of your time. I'm putting the link here. Anyone who got any value, saved any time, effort, money, etc., stress, please click on this link. It will take 1 minute of your time and it will help others like you to find the Google business page, and they will connect to the YouTube as well. So, and there are a lot of resources on the YouTube channel as well. So please do give your 5-star review. Click on that, give a 5-star review, write 1 or 2 lines. It will help me, the channel, everyone else. Will the caseworker right to request English test or not? Usually they will, but you are asking too much from the home office. Yeah, so yes, they will ask for the English language test. Ideally, yes, first time. Devjyoti Saha, what details are required from the applicant? POV. What is POV? Sorry, I don't know all these short forms. Before the course is assigned, what details are required from the applicant? And what details I would need to fill when applying for skilled worker? Okay, it's too much detailed explanation that you are asking. A skilled worker application is a long form. It's a lot of information it will ask you, personal details, work details and all. On the course, it's mainly the job details and your details. That's what I can tell you summarily. Yeah, for further details, if you want, you can book a consultation and I can show you on screen and try to tell you what they will be asking. In skilled worker visa case, visa application submission. What applicants are required from the applicant's point of view before cause is assigned? What details are required? Employer just needs your details, your passport details, your name, that's it, nothing much. Shauna DeCosta, hi. With all the new rules and changes that are happening, can the retained rights of residents, so this is about EU settlement scheme, she's asking, still apply for someone that will be going through the divorce process, still get the settled status if they qualify? Yes, they will. I have several applications, appeals and everything, yeah, filed. Sometimes people do it and they mess up and we have to file appeals. There are applications also we've done successfully on the retained rights. So if you want advice on your matter, retained rights is still there, the rule is there. So anyone who is separated from an EU national who was a family member, a former family member of an EU national, has some status under the EU settlement scheme, usually a pre-settled status, and if they meet the requirements, usually it is with partners. If you're married to a EU national and you marriage has existed for, this is the most common one, there are others also, there are 3-4 others. This is the most common one. If you're married to an EU national for at least how many years? At least 3 years. Of that, for at least 1 year you have lived in the UK, lived together, you have evidence of that, and you have pre-settled status as a family member, then you can apply for retained rights. So what that means, the rights transfer from that EU national being connected to you, even if they separate from you, the rights are transferred to you, and then you can apply for continue living in the UK, and after 5 years you can apply for settled status in your own right without the EU national. That is retained rights summarily. Yes, with all the rules changing, retained rights will still stay. There will be a lot of litigation if they try to stop it. Don't worry. Yeah, I have done considerable amount of cases in that area, so I am aware of that. They cannot just suddenly stop that rule. Landry, if a wife, thanks Shauna. Yeah, if it did help you, yes, again, I'm asking for help from your side. Please do consider giving a review on Google. It will take 1 minute of your time, Shauna, if my answer helped you. And to give a Google review, just 5 star and one line you can write down. I'll put the link over here. It will help others like you to find this channel. So I'm just encouraging everyone. There is a Google business profile. It's not very well connected to the YouTube channel, so we are trying to get it connected properly. If you do go and give a review over there, the YouTube channel, somehow we are trying to connect it over there. We will end up somewhere, I think. We are putting the videos also there so others can find this channel, find the resources, find the answers in lives, etc. Andre, if a wife, next live question, if a wife starts a company with another partner, can the company issue a cost to her husband and she becomes a dependent? Interesting. Yeah, it is possible, yes, as per the books. But yeah, whenever the assignment is happening, the level 1 SMS level 1 user cannot assign a cost to a relative. So make sure both of you are not assigning to each other. Whatever that is, you get a legal representative. Home office will ask questions that has to be declared if relatives are assigned causes. Explanation has to be given. Job is genuine, everything. Home office will assess all those things. Whereas yes, practically it is possible. Relatives can be sponsored, but home office has to be notified while assigning the costs and all. And relatives cannot assign costs to a relative. Remember that. These are all the restrictions as per the sponsor license compliance requirements. So get a lawyer involved. You can get advice from us or any other lawyer and get it done. But home office will question, they will ask for genuineness, evidence and everything. Business is genuine, job role is genuine. That is very, very important. They are focused on that. They are asking for a lot of documents, bank statements, etc., etc. Nowadays, I have made another video explaining the documentation they are asking for the causes, U cause, D cause. You can watch that video, it is on the channel. Aryan, I will apply ILR on 10-year long residence. During this period, couple of my visas I applied well before expiry of my current visas, but new visas were granted months later. How to address this? You don't have to address this. I remember you asked in the previous live for long residence application, is it okay you just give all your passports in the last 10 years? And I said yes. That will have all the passport stamps of your entry and exit. That will show your absences are within the limits. So not more than 180 days in any 12-month cycle. Yeah. So yes, you don't have to explain those things. Whatever you asked for, Home Office has a record of all of that. That is Home Office problem. Once you file the application, it's Home Office problem. Landry, and if you did get any information from Landry, you said thank you very much for watching the live, for asking the question. I hope my answer helped you, or I at least help you with enlightening you what you may be faced with. So please do consider giving a review on that Google link. I'll put it again. It will take 1 minute of your time, but it will help others to find the channel as well, and it will help the YouTube channel to go to many other people. So that's what I am trying to promote. I'm trying to connect that Google business page to this YouTube channel somehow. So, and just give a 5-star review, write one line or one paragraph or one page review over there. Aryan, thank you very much. I thought I need to provide explanation to Home Office. Don't worry, you don't have to provide explanation. If you are worried about all these questions, you can speak to any immigration lawyer, book a consultation with me, ask all your questions, or you can also get reviewed your application. We provide checking service and all of that. I understand not everyone can afford the full service fees or whatever your constraints are. There are different types of services that we do provide. You can go on the website, which will be on the in the channel information. If you click on the website, go to the book online option, all the fees information is over there for any checking services, support services, consultations, everything is there. So you can consider that whenever you are eligible. Okay. And what else? Yes, there are no more questions. I will end this live. I may do the lives next week. I'm encouraging everyone, please do click on that Google review link. It will be also in the description of the channel. And please prefer giving a 5-star review and write one line review also. That is more than sufficient, or a longer review. Thank you very much anyone who joined. Thank you, and have a good weekend. Thank you.